नमस्कार दोस्तों, आज जिस विषय पे मैं बात कर रहा हूँ वो टॉपिक है जनरल पावर ऑफ अटॉर्नी। तो जनरल पावर ऑफ अटॉर्नी क्यों दिया जाता है और कौन से हालात में दिया जाता है। जनरल पावर ऑफ अटॉर्नी इज अटॉर्नी विल बी अपॉइंटेड ऑन बिहाफ ऑफ यू टू लुक आफ्टर योर मैटर्स। कई बार ऐसा रहता है कि अपन प्री ऑक्यूपाइड रहते हैं अपने बाकी बिजनेस मैटर्स में, नहीं तो अब्रॉड रहते हैं फॉरेन कंट्रीज़ में, या अपने ट्रांजैक्शंस रहते हैं जो कि समवन हैज़ टू लुक आफ्टर दोज ट्रांजैक्शंस, और लीगल इश्यूज लाइक केसेस आर पेंडिंग इन इंडिया एंड यू आर इन अब्रॉड। तो आप यू वांट टू अपॉइंट समवन टू लुक आफ्टर द दोज केसेस और योर बिजनेसेस, योर मनी ट्रांजैक्शंस, योर एसेट्स और योर बैंक अकाउंट्स और समथिंग विच इज़ lying in one country and you are staying in another country. लाइक इंडिया में आपके ट्रांजैक्शन है, डिफरेंट ट्रांजैक्शन लाइक जैसे प्रोजेक्ट्स है, नहीं तो बैंक बैलेंसेस है, नहीं तो मनी ट्रांजैक्शंस है, कोर्ट में केसेस है, या आपके और कई ट्रांजैक्शन है जहां आप अवेलेबल नहीं रह सकते किसी कारणवश। आप नहीं तो आपके हेल्थ कंडीशन विल बी नॉट गुड दैट यू कैन अटेंड दोज इश्यूज़। तो आप क्या है अपनी तरफ से एक एजेंट को अपॉइंट करते हैं who will be assigned to look after your personal issues like cases or your money transactions, bank account transactions, or if you are in a foreign country, you want your matters to be looked after in India, you will be appointing someone to look after you as a GPA. That is called general power of attorney. So general power of attorney कितने तरीके के हैं? This is the question. General power of attorney is one. It is called general power of attorney. Gives a broad authorization to the agent. The agent may be able to make medical decision, legal choices, financial or business decisions. This is generally you will give someone the responsibility as general power of attorney. Next है special power of attorney रहता है एक. Special power of attorney will be given with regard to special issues. Those will be a narrow issues which will be looked after by your person. तो ये जो स्पेशल एजेंट है आपकी तरफ से, स्पेशल पावर ऑफ अटॉर्नी, तो वन पर्सन टू एक्ट ऑन बिहाफ ऑफ अनदर टू लुक आफ्टर फाइनेंशियल मैटर्स, मस्ट बी ट्रस्टवर्थी एंड हैविंग अथॉरिटी टू मेक डिसीजंस ऑन योर बिहाफ विथ रिगार्डिंग ग्रांटिंग पावर ऑफ अटॉर्नी. सो मनी ट्रांजैक्शन रह सकता है आपका, नहीं तो कुछ भी बिग एसेट्स और वर्क्स will be done on behalf of you. He will be called as special power of attorney. And third आके durable power of attorney बोल के भी रहता है. What is durable power of attorney बोल तो the power of attorney is effective even if you are incapacitated. This is something called enduring power of attorney. When we will use it? When you are looking for an aid to represent you in important matters, person is unwell, in position, carry out critical transactions, and when the person is abroad, he wants his matter to be looked after like a better to assist in domestic businesses. If you are preoccupied with other appointments or works and something and unable to concentrate on a particular project task, these are some of the points in which you will be asking for durable power of attorney. And other points are that what does it covers, actually क्या cover करता है ये durable power of attorney. Attorney's power relating to conducting your business, real estate and property matters, selling and buying investments, operation of bank accounts, power to enter into agreement and registrations, other basic and vital clauses. These are the things will be done by your power of attorney. And एक और बात, the question comes into mind that if the person who has given power of attorney, if he suddenly expires due to medical issues or something, what will be the condition of the agent or the GPA which was being executed by the principal or the person? So what will be the fate of the GPA? तो उसके बारे में क्या है, if you create a power of attorney, you appoint an agent to make decision on your behalf. These decisions about your health care or your finances. If you passes away, other estate planning document, usually a list, last will or trust, then take precedence. अगर आप पावर ऑफ अटॉर्नी दे रहे हैं, कोई भी दिया आदमी, और उसके हेल्थ इश्यूज़ के बारे में दिया हो, नहीं तो उसके फाइनेंशियल्स के, अगर दैट पर्सन gives a will, executes a will on his behalf. जैसे ही उन्होंने मरा तो ये will come into picture and the power of attorney will be ceases its power. That is the question, when the power of attorney will be stop working, or you can say it will cease its power, and the will come into picture, and whatever is there in the will, that will be implemented. Like, तो पावर ऑफ अटॉर्नी के बारे में और बताया जाए तो जनरल पावर ऑफ अटॉर्नी की नेसेसरी क्या है, वाई दोस जनरल पावर ऑफ अटॉर्नी विल पीपल विल ऑलवेज एग्जीक्यूट, लाइक व्हाट इज़ रीज़न बिहाइंड इट. तो इसके बारे में क्या कह सकते हैं अपन, स्पेसिफिक जैसे है तो स्पेशल टास्क, हैंडलिंग योर टैक्सेस, साइनिंग लीगल डॉक्यूमेंट्स एंड सेवरल अदर इश्यूज विल बी looked after by your agent. That is the reason why you will appoint a GPA. तो अगर there is one question which will be raised in cases pending before the courts. जब आप कोई power of attorney किसी को दिए to look after your business or principal, institute suits or defend or oppose all suits that might be brought to or against the principal, against the person who is executing. अगर the case will be compromised in a condition that it has to be compromised, unless and until there is a point in the GPA that he has the power to compromise the matter, the agent cannot compromise that particular case until the person executant is not there or the principal is not there. This is judgment which is Chatterjee Brahmin versus Durga Dutt Agarwal, year 1916, Calcutta 507, where it was questioned with regard to whether the agent can enter into compromise on behalf of the executant of the GPA. The power authorizing the agent to manage the business of the principal. No institute suits and defends or oppose all suits that were or might be brought by or against the principal. Does not entitle an agent to compromise a suit by or against the principal. So he cannot have the authority unless and until the GPA contains a clause that he can even enter into compromise on behalf of the principal or the executant. Then only he can enter into compromise. The authority to compromise must be expressed in the deed of the power of attorney. That is very much important. Even a legal practitioner or pleader cannot compromise a suit on behalf of his client unless express authority has been given to him by the terms of his engagement. So अगर वकील साहब भी अगर कॉम्प्रोमाइज़ करना चाह रहे हैं अपने क्लाइंट की तरफ से, तो वहाँ पर स्पेशल एंगेजमेंट वर्ड आना चाहिए उनके अपॉइंटमेंट में, दैट ही कैन इवन एंटर इनटू कॉम्प्रोमाइज. दैट इज देयर इज नो सच पावर inherent in him. Power to prosecute the suit does not include power to withdraw the suit or settle it by way of compromise unless specified in the power of attorney. ये एक point which was been is pronounced by a judgment wherein Manmohan Singh Dhaliwal versus Gurbaksh Singh 2002 AIH C275 Delhi. इस केस में कोर्ट ने फाइंडिंग क्या दिया, पावर टू प्रोसिक्यूट द सूट does not include power to withdraw the suit or settle it by way of compromise unless specified in the power of attorney. तो power of attorney में compulsory the clause should be there that the particular person on behalf the GPA is given to whom the agent, the clause should be there which says that he has the right to compromise on behalf of the principal. And another point comes with regard to money transactions and issues, whether he can lend the money, the agent, GPA holder, or he can enter into promissory note or any money transaction. So there is a judgment to that effect. Aday Kappa Chettiar versus Thomas Cook and Sons, Bakers Limited, AAR 1933 PC 78, in which the court has given certain findings saying power to endorse and accept bill of exchange did not confer the power to back bills, and the power to pay checks did not include the power to promise to pay. This is the judgment wherein it is stated that the bill of exchange did not confer the power to back bills, and the power to pay checks not include the power to promise to pay anyone. So promissory you cannot execute unless the clause is there in the GPA. This is judgment. And another judgment where the principal is not carrying on any business which may involve executing, accepting, or endorsing of bills of exchange. The agent has no authority to execute promissory notes on behalf of the principal, either expressly or impliedly. So, when the person who is executing GPA, he does not operate or he is not carrying any business which involves executing, accepting, or endorsing bill of exchange, then the agent have no authority to execute promissory note on behalf of the person who is executing GPA. That is the judgment of Ram Hetliar versus Banwari Lal, year 1938, Lahore 41. This is judgment where in those two judgments it is very much clear that the clause of endorsing with regard to promissory note, money transaction, money bill exchange, everything should be reflecting in the GPA. Then only the agent can execute all these things or enter into issuing these all promissory notes and accepting the endorsing or exchanging the bills of transaction and promissory note. These are things to be very much mentioned in the GPA. Then only the agent can enter into such transaction. And another thing is with regard to when cases are pending before the courts, what is the, if the clause is there that GPA is there and everything, if a person files petition before the court or suit before the court on behalf of the principal or GPA holder or whatever may be, what will be the fate of the case at the time, whether the GPA fresh can be filed at the time prior to the argument, or what is the stage when the GPA, a fresh GPA can be filed before the court. It is judgment Vairavan versus Harvey Perianna Chettiar 2006 3 CTC 486. Application filed at the stage of argument to permit one of the plaintiffs to act as power agent of the other plaintiffs. So one of the plaintiff want the to be represented on behalf of remaining applicant plaintiffs. No permission was sought for at the time of institution of suit. The defect is curable. Such application can be filed at the final stage of the suit, and there was nothing improper for the trial court to allow the same when there was no prejudice caused to the defendant. So this is a question that was been uh, founded by the judiciary in that particular case. And another point is whether the court has the power to inquire into the GPA sanctity or whether those documents are genuine or not, whether appointing a GPA correctness or not, whether the court can put certain questions. No. It is judgment where is Tukaram versus Bhimrao 1996 4 ELD 439. Court cannot embark on any inquiry into reason for appointing a GP and correctness thereof in executing a power of attorney. There is another judgment with regard to this also. Chinnamna versus Bandari Pedda Bhumanna 2004 1 ELD 241 Division Bench. These two judgments are with regard to that the court cannot inquire into this appointment of GP or correctness of the document. And another thing is with regard, which is very much important subject in always been in question, whether person who is living in abroad can appoint someone on his behalf of him to defend his case or to look after his case in India. So there is a rule in civil case, the institution of suit by agent on behalf of plaintiff residing abroad. If a person want to institute any suit before the civil court, whether he can file on, the agent can file a suit on behalf of the principal or the person who executed GPA. Yes, there is a clause in our CPC. It is Order 6 Rule 14 and another is Order 3 Rule 2, where a suit is instituted in a court of India on behalf of plaintiff who resides abroad permanently. So this is very much important that person who wants to file a suit, he is not resident of India, he is permanent resident of abroad country. Then this Order 3 Rule 1 and 2 will come into force, and this is the CPC which says about it. The provision of Rule 14 Order 6 as pointed out in Bengal Jute Mills versus Jurel Hiralal AR 1943 Calcutta 13 at page number 15 does not apply to the case of party permanent residing outside the country. So if a party resides outside the country, then order 3 rule 1 and 2 will come into picture. That will be applied. The rule has to be followed in CPC case where the plaintiff who is residing permanently in abroad want to file a suit, or so his agent can file suit under rule order 3 rule 1 and 2. And if someone want to raise objection with regard to this GPA or anything, the when such GPAs are filed before the court, and the defendant want to raise certain question with regard to its admissibility in case, then he has to raise those issues at the beginning of the trial itself. There is a judgment to that effect also. Here it is, an objection must be taken at the earliest possible opportunity in the trial court. An objection to the validity of a power of attorney must be taken at the earliest possible opportunity in the trial court. The judgment is Municipal Committee Pathankot versus Roshanlal AIR 1957 Punjab, page number 1443. And also another case is there, which is Western India Theatres Limited versus Ishwari Bai Sombai AIR 1959 Bombay Division Bench, page number 386. And there is another judgment which says, if someone does not raise any question at the beginning only with regard to validity or admissibility of GPA, then there is judgment which says, if you will not raise any question at the beginning of the trial, it will be deemed as if it is waived by you, or the defendant has waived the right to object the sanctity of the GPA. That judgment is Khatun B versus Amina B AIR 1953 Mysore 89. This is division bench. It says, if not taken must be if the objection is not taken at the beginning, it must be deemed to have been waived by the defendant. These are the things that are very much important with regard to GP, and when the question of objection should be raised by the defendant in civil suits. And with regard to criminal cases, when a complainant who has filed suit case before the court and suddenly he expires, whether his children has to will be coming on record, or children can file the agent of the children can file a petition before the court to pursue the matter. It is a judgment of Jimmy Jahangir Madan versus Boli Karyappa Handle 2004 AIR SCW 624 6248 page number. Application under 302 of CRPs to continue proceeding can be filed by heirs of the deceased complainant but not by their power of attorney holder. This is judgment which says the power of attorney cannot file continuing proceeding cannot be filed by him on behalf of the complainant. His legal heirs has the right to file those petitions. And these are some of the rulings. Another judgment is with regard to power of attorneys. This is power of attorney executive principle in foreign country. If a person who want to execute GP and who lives in foreign country, how he has to, what is admissibility of that particular document, under which provision or section? It is section 85 of Indian Evidence Act, which says it is well settled that document of power of attorney duly attested by a notary public coming from a foreign country must be presumed to be validly executed, as has been laid down in section 85 of Indian Evidence Act. And such as the judgment is Charan Kaur versus Pakar Singh AAR 2004 Punjab and Haryana High Court 121 page number. This is the provision of law with regard to GPA holders, and if a person resides in a foreign country, and then how the GPA on behalf of him can be filed by him or his legal heirs, the agent, GPA holder. So what is the validity of that GPA which was being signed by a person who resides abroad, and how he can file those documents, or what signature he has to obtain, how it has to be attested. So this question is very much important, because one who resides at abroad, he has to take signature of the attorney, like a GPA want to sign, he has to sign before the consulate, before the Attorney General or someone who is official of that consulate of India in that particular country. You have the document has to be signed before him, and that person has to, the official has to authenticate the document that it has been executed before him. That is a provision of law, very much important with regard to GPA filed by the abroad person who is residing in abroad foreign country. So these are some of the important points with regard to GPA's sanctity or validity of any GPA, or how many types of GPAs are there, and whether GPA which is filed before the court, when the objection has to be raised by the respondent or his counsel, and if he fails to take objection at the beginning itself, it will be deemed as if it is waived by him the right to object the GPA. And with regard to if anything is wrong with regard to filing in the GPA, the subsequently GPA can be again filed a fresh GPA. That point cannot be raised before the trial court, that is the judgment of own high court. If another judgment is with regard to if a lady, there is a civil cases will be pending in diverse matters and all, if one of the parties stays in abroad, what will be the scenario? It is a case of Komal S. Padukone versus Principal Judge Family Court, Bangalore City, AAR 1999, Karnataka 427. The wife was staying in USA and had left India before notices in diverse proceedings were served. She felt it would be difficult for her to go over to India before a particular period. Hence, sought permission to engage a counsel exemption from personal appearance till that period. The Karnataka High Court held that there is nothing unreasonable in the said request. Ultimately, the ex parte order passed on her application by court below was set aside. So, such is the GPA and GPS findings, and when the GPA is applicable, or what is the sanctity of GPA. Thank you very much, friends. My name is Srinivas Advocate.